Welcome, this is Professor Guerra Pujol from the University of Central Florida, and welcome to the Legal and Ethical Environment of Business. In this first batch of videos on intellectual property, or the law of ideas, we've been focusing on copyright law. We've seen what it takes to create a copyright. It's any original work that you can express on a fixed and tangible medium of expression. And we've seen the broad definition of copyright infringement, including indirect infringement. And we've even seen some of the leading cases, for example, the Sony Betamax case. Here, however, I want to talk about the fair use exception, or the fair use doctrine. And I have my gavel because although the fair use doctrine, or the exception to copyright infringement, is codified in the federal copyright law, the fair use exception was actually created by judges in trying to balance the property rights of copyright creators, artists and Hollywood and musicians, etc., and copyright copiers, you and me. We'd like to share these files and share these works of art with each other without having to get authorization. And that's what the fair use doctrine does. And I have to say, a fair use is so important, not only because it carves out a huge exception to copyright law, copyright enforcement, property rights and copyright, also because it illustrates sort of a larger lesson about the law and what courts do on a day-to-day basis. And that is try to balance the rights and interests of competing stakeholders. In this case, the competing groups are copyright creators and copiers. And the idea is that no legal right is absolute. All legal rights have exceptions, even constitutional rights have exceptions. And courts, what they have to do is draw lines and find difficult balancing of rights when those rights conflict. So let's talk about, let's focus on fair use, because that's what I promised to do here. And it's actually a very, very important exception to copyright. Now, let me first tell you what fair use is not. A lot of times, for example, here, I work at the University of Central Florida. I'm an instructor. I've oftentimes received guidelines, don't use more than 10% of a copyrighted work to avoid infringement. Well, that is exactly what copyright fair use law is not. It's not hard and fast rules. So this is another important lesson about law. Copyright, fair use and specifically, is about factors, balancing these various factors and looking at them holistically and qualitatively. So there's no hard and fast rule about what constitutes fair use or what constitutes infringement. Instead, courts will look at the 4 following factors. So let me tell you what these factors are and then discuss each one of them in a little bit more detail. I will tell you, for example, in the Napster case, the courts applied the fair use factors and found that they were not met. Now, the fair use factors, 4 of them. One is, and I'll just list them, then I'll explain what they are. One is the purpose of the use. Now, let's just assume you have somebody blatantly copying or infringing on someone's copyright. What we want to know is, does it fall in the fair use exception? And so the first thing we ask is what is the purpose of that use, of that copying behavior? Second, we want to look at the nature of the copyrighted work. I'll explain that momentarily. Third, we want to know, the third factor is the amount of the copyrighted work that was infringed or used or borrowed, depending on the terminology you prefer. The portion used in relation to the copyrighted work as a whole. And the fourth and final factor, personally I think is the most important one, it's the effect of the unauthorized use upon the potential market. Now here I'm assuming we have an infringement, but I shouldn't really say that, because what fair use does, fair use tells us whether there is an infringement or not. But here I am assuming there's a blatant copying going on. And what we want to know is, does it fall in fair use? So let's look at these 4 factors. And let's start with the purpose of the copying. why is someone copying? Actually, let me take a step back. No, let's just go ahead and move forward. Here, the example is, for example, what I do in this class. I've shown you some film clips from The Social Network, for example, the movie describing the founding of Facebook. But I'm doing that for an educational purpose, right? I want you to see how law and ethics applies to a real life business, a business that has really revolutionized and touched all of our lives. Also, Saturday Night Live, which I love Saturday Night Live. The new season is about to begin. So it's a great show. And a lot of times they'll do spoofs, right, of actual, products. They have these like spoof commercials. And in other words, parody. That's another purpose. That's, it's okay to do a parody. It's okay to do some copying for, educational purposes. News reporting. So what the courts have done is they've said, look, there are a number of purposes that are okay. If you're doing some copying or, potential infringing for educational purposes or parody, etc., news gathering, you're writing a book review, you want to be able to quote parts of the book, that's okay. But remember, this is just one of the 4 factors. Even if you are copying someone else's work without authorization for educational purposes, or to perform a parody, or to gather the news, you might still be in infringement if you don't meet the other 3 factors. There's 4 factors altogether. Purpose of the use is just one of the factors. The other factor, if you recall, is, let me just look at my notes so I can be organized here, is the nature of the copyrighted work. This factor isn't as important, but basically, what is the infringer or would-be infringer? What are they copying? Is it a book? Is it a work of art? Is it a photograph? And the idea is, here's the broader idea. The courts want to know the context in which the copying is going on. And the context can matter. Now, the purpose, or I should say the larger point here, is that this is fair use, it's case by case. You want to look at the 4 factors. And you want to look at, okay, what exactly is being copied? Now, the third factor is how much copying is going on. Right? So if the first factor is, I look at it this way, purpose of the use. Why are you copying? The second factor is, what are you copying? And the third factor is, how much are you copying? So the idea here, and again, notice, there's no hard and fast rule, like 10% or 5%, but the idea is a sliding scale. The more of another person's work that you copy, right, the more likely it is you might be found in infringement. And the less of the work that you copy, the less likely it is that you'll be found in infringement. Again, the context matters. Again, going to our case here in this course, I've shown you a few film clips from The Social Network. For example, the face mash scene where Jesse Eisenberg is asking for the algorithm from Andrew Garfield. But I'm not showing you the whole movie, so I'm just showing you part of a small clip. I think it was 1 minute and 7 seconds altogether. And the movie, I believe, is 90-minute movie. The purpose of that was, of course, educational, to show you that face mash may have had some creative elements to it, although clearly, Zuckerberg was using those pictures without his classmates' consent. What it is, though, that I'm borrowing from, if you will, is, of course, a copyrighted movie produced, I believe, by Columbia Pictures. Now, I should say it, I feel comfortable that I'm in fair use because Columbia Pictures, right, they could have sent a takedown notice to YouTube, which is where I got the videos from, and I don't think they have because those videos are still up on YouTube. Right, so I think Columbia Pictures wants me to share some short film clips with you, hoping that you might want to see the rest of the movie. And that leads me to my 4th factor, the effect on the market of the unauthorized copying. And I think that's really the bottom line. I really think that's the most important one. I think that's why Napster lost, whereas Sony won in the Betamax case, is because if you look at Sony, right, what they're doing is by making it easier for people to copy TV shows. It's true they're going to fast forward the commercials. I certainly do that with the DVR. But at the same time, I'm going to copy a whole bunch more TV shows. So I'm going to be watching more TV shows. And if you think about it, that's expanding the market for those TV shows. In the case of this course, I'm showing you a short film clip of the movie, and I'm really hoping you'll go out and see the movie, even if you've seen it again, so you'll see it with new eyes from a legal and ethical perspective. And the idea is, right, you go out and pay for the movie. So I'm actually helping to expand the market. Or if you were to write a book review and you have a few quotes from the book that you are reviewing, to the extent that readers might go out and buy the book, right, you're expanding the market. The effect on the market is positive. Here's where Napster's a lot different, right? Napster, by making file sharing, so easy to do, in reality, the sales of CDs just plummeted dramatically after Napster. In fact, to give you some idea of how popular Napster was, is after it was created and launched, I believe in June of 1999, shortly thereafter, about a year or so thereafter, there were 26 million users, mostly college students, of Napster. And that had a dramatic effect on the sales of music. Now, footnote, in fairness to Napster, I think you could argue, and we'll maybe see this in a separate lecture, antitrust law at the end of the course. CDs were almost $20 a pop. If you only wanted one song, it was, you'd have to buy the whole CD. The iTunes and iPods weren't out yet, readily commercially available. So it was really difficult. Once iTunes came out and allowed you to buy a single track for 99 cents, right, that changed the whole model of the music industry. There was a legal way of just getting the music you wanted. But the larger point here is fair use. All right, so, and here's the larger point about fair use. It's 4 factors. The courts will look at fair use on a case-by-case basis. There's no hard and fast rule. In fact, cases that involve the fair use defense usually very expensive to litigate because the court will have to go into each of the 4 factors. But now you know that courts will balance the rights of copyright owners with the rights of consumers and people who want to copy the works of others. And that to me is a really important point. Yes, property rights are fundamental, they're essential in any well-functioning economic system. But at the same time, you have to allow a little bit of give and take. You have to allow a little bit of copying, And what is the optimal amount? Well, we have the 4 factors. What you see here is the courts and now Congress, in incorporating the 4 factors into the copyright law, trying to strike that balance. And that is a great lesson for the law overall. Courts are trying to strike balances between competing parties and competing interests. Well, thank you for your time. In our next set of lectures next week, I'll jump into trademarks and then trade secrets and patents. Thank you again for your attention. Have a great week and go Knights.